Hello guys, and welcome to the Legis Law channel. In this particular session, I'm going to be taking you through how to answer law problem questions using the IRAC formula. Now, many students have a particular challenge with addressing problem questions, unlike the other types of law questions such as the essay questions or the multiple choice questions. Now, we are looking at problem questions. These particular type of questions raise what is known as facts. Now, facts are basically events or occurrences that create what is known as matters of contention or disputes between the parties. So in these problem questions, there are a set of narratives or facts that are raised. So certain factual matters or situations that occurred that raise matters of contention or disputes or conflicts between parties. So the parties are persons, either natural or artificial persons, right? So we have the natural or artificial persons. Now these persons can be in conflict with each other, basically on a legal issue. So for the problem question, the examiner wants to test your analytical skills, your ability to raise and identify the conflict between the parties, and your ability to address those conflicts using the relevant law known as the rules. So the rules are the relevant laws that will be able to address the matters in contention between the parties. So this is known as the IRAC formula. That is the issues, the rules, the analysis, and then the conclusion. So we start with the issues. The issues are the matters in contention between the parties. These are the disputes that must be settled by the relevant law. Now, to determine the issues, you need to first of all determine what is the area of law. Now, the area of law is the broad topic or the broad scope under which the issue might fall under. So we are looking at the particular area of law being the topic, such as capacity to contract or establishing criminal liability using the actus reus or the mens rea. The area of law can also be misrepresentation in contract or mistakes in contract or remedies such as damages or specific performance. So in this sense, the area of law is simply the broad aspect, and the issues are the particular questions that arise, the particular disputes between the parties. So the disputes are raised or phrased in a question format, whether or not. So whether or not there is a contract that is binding between the parties. But because we know the relevant facts right here, for example, a 15-year-old child goes to a shop to buy a particular bag of rice. Now, the main matter in contention is whether or not the contract is binding on the 15-year-old child. This is because of the fact that it is assumed that minors are not bound by contracts. But this falls under certain exceptions, such as contracts for necessaries. So in this case, instead of raising the issue as whether or not there is a binding contract on the minor, you can phrase it to include the relevant facts. So the fact plus the issue will be whether or not the rice seller can enforce the contract of the rice purchase and sale against the 15-year-old child. So whether or not the rice seller can enforce this particular sale and purchase agreement against the 15-year-old child. So now you've raised the facts and the issue, right? You've included the relevant facts in the issue. Instead of just raising broad or abstract issue, it is recommended to include the facts in there and make it very, very specific. Now, after raising the relevant issues, you need to identify what is known as the rules. these are the appropriate law, right? The law. So what is law? Law are any particular provisions or precedents or principles that are legally binding or recognized as an authority. So it can be an instruction in a statute, a provision to do or refrain from doing something. So there can be a statute like the Sale of Goods Act of Ghana or the Sale of Goods Act of England or any other country. This particular statute might state that a contract entered into by a minor is not binding unless it is a contract for necessaries, that is essential goods and services. So in that case, we have a provision under law known as rules in a statute. This particular statute has raised an applicable provision or a principle. Now the principle can also be found in case law. So the case law is the precedent. For example, a popular case law on the topic can be the case of Chappell and Cooper. So Chappell and Cooper is a particular English decision in which the court decided that a contract for the purchase of a coffin was a necessary contract. It was a contract for necessaries because of the fact that the coffin was something that was essential at the time, since the minor was going to bury her husband. So the lady was below the age of 21 and her husband had died and she needed to buy a coffin. The court held that the coffin was an essential material that she needed. So it constituted a necessary. So in this particular case, you realize that we might have a statutory provision and we might also have a case law on the topic. So all these will fall under the rules, right? So the rules are the appropriate law. With reference to the rules, you can also look at constitutional provisions. I already mentioned statutory provisions. We can also look at subsidiary legislation, like legislative instruments or executive instruments or bylaws. We can also look at common law, as I said, the precedent, or principles of equity. We can also look at the customs and the usages in that particular business environment, or the customs of the particular community. So these are the rules. In fact, international law or international custom can also be part of the rules. You are simply supposed to identify all the relevant rules that fall under the particular issue. Now that you've identified the rules, the next thing is the analysis. The analysis is also referred to as the application, right? So what are we applying? So in reference to the application, we are applying the relevant law to the fact of the case, right? That's the problem case or the hypothetical case. So we are applying the law to the facts. And what is the purpose of the application? We are doing the application to analyze and solve the issues, right? To analyze and solve the issues. So in this particular sense, what you must note is that once you've raised the relevant rules and you have your problem, that is whether or not the contract is binding on the minor, something to that effect, you apply your rules to the facts. And so you say that according to the facts, the particular individual is a 15-year-old boy. So he is a minor. Under the general law, contracts are not binding on minors unless it falls under certain exceptions, such as a contract for necessaries or a beneficial contract of service. So in this particular case, in your analysis and your application, you are going to then determine the issue and come to a conclusion. So now that we know that it was a contract for rice, and rice is food, and food can be deemed to be essential or necessary to the standard of living or to the existence of the particular individual, the next thing we are going to do is to give a final legal opinion and our conclusion. So the conclusion is your final legal opinion or advice to the particular party. It is the remedy that you are instructing the party to apply for, or that you are proposing or recommending to the party. So in this case, such as the case of our hypothetical situation or problem question, you can advise the rice seller to take an action to enforce the contract against the minor, since the particular contract for rice is binding on the minor. In this particular case, it is a contract for necessaries. So your advice can be in the conclusion, that is the final expression of your legal opinion on the particular matter. So we've raised the issues, right? We've raised the issues, and then we raised the rules, and then we also did the analysis or application, and then we came to our advice or conclusion. Now, there are certain key points that I want to address. Number one, make sure you clearly identify the issues, right? You have to clearly identify the issues. And the reason for that is that once you get your issue wrong, it means that you might be addressing the wrong problem. So your rules will also be probably wrong, and your conclusion and analysis, your analysis and conclusion will also be wrong, because the problem was wrongly identified. So if the problem is wrong, the rules will also be wrong, and then the analysis will also be wrong. So you must make sure you identify the issue properly. Then you must also make sure that in your analysis, you take note of relevant facts, right? Relevant facts. So in reference to that, you need to apply the rules or the precedents or the principles or the law to the relevant facts. So don't talk about whether it was fried rice or jollof rice or a bag of rice or a cup of rice. Those particular problems are not relevant, or those are not relevant facts. You need to determine the relevant facts and apply the law to the relevant facts. You also need to be clear, okay, and brief. You also need to be straightforward and organized, right? So you also need to be straightforward and organized. And this particular thing is going to be essentially tested by the examiner. They want to be able to determine whether or not you can identify a problem, determine the rules and the laws that will address that particular problem, analyze and apply the laws to the relevant facts, and come to a reasonable legal opinion or a reasonable conclusion or advice to the parties. So the major mistake students do is the wrong identification of the problem. This is because they've not really correctly studied the various areas of law. If you've not learned capacity to contract really well, you might not be able to identify the problem, and you might not be able to identify the rules. So of course, to know the relevant rules, you must learn the law really well. You must read widely and broadly on the particular topic. You must do your own research and be able to memorize or understand some of the key principles in there. Example, the key cases like the Chappell and Cooper that I had mentioned prior. So in this particular case, once you are forgetting relevant rules, you are showing to the examiner that you are simply disregarding the applicable law, or you are not able to recollect the applicable law. In some good situations, they might even make it an open source or open book exam, in which the relevant law will be in front of you. You'll be able to easily access it. In that case, the examiner is looking for your analytical skills, how to analyze a problem, to raise the relevant issues, pick the laws from the textbooks or the material provided before you, and then address it with proper analysis and come to, as I said, a reasonable conclusion. So this is how to address problem questions using the IRAC formula. I repeat, the issues, the rules, the analysis, and the conclusion. Sometimes or most times, you can also start with the identification of the area of law, which will help and guide you towards raising the relevant issues. So to conclude, you need to also make sure that in case you are writing by hand, it is legible. In case you are typing, it is very coherent and well organized. This is different from essay questions because they have a different structure. That is the topic, sentence in the introduction, as well as the main body and conclusion. Other forms of questions can be the multi-choice questions, whereby you'll be told to choose a particular answer from a set of probable answers. So the IRAC is where most students have the problem. So once you believe that you've been able to understand the core structure of IRAC, you simply have to practice and address many more problem questions. So thank you very much for having a good listen to this particular session. If you found it relevant or useful in any form, I'd like you to share, like and subscribe. Till next time, tada!